Welcome to everybody. It's good to see you all on another Tuesday. If you're here in central New York, it's a snowy Tuesday. But if you are in other parts of the state, it might not be so snowy. I am going to start off with a COVID update for everyone. Next slide, please, Kathy. So I wanted us to take a look at the current numbers in New York State for a couple of reasons. First, so that you can see what's going on statewide and then in specific areas, but also to highlight the fact that we may have some changes coming. We have enjoyed the last month or two of consistently declining numbers. It seems like that is coming to a little bit of an end. There are many theories about why. Some people feel it's the new variant. Others probably correctly think that it's the reduction of mask wearing. But here's where we are. If you see in New York State, currently as of March 28th, we have 2,918 cases in the day. Daily average, 7-day average. The 14-day change, that's up almost 80%. So that is a big increase that we're seeing. Testing is up mildly, but not too much. Hospitalizations continue to go down. ICU numbers continue to go down, but those are lagging numbers. Those typically trail behind the case numbers. So right now we're seeing an increase in case numbers, but as of today's date, right now when I'm talking, we haven't seen any changes in policies. Next slide, please. And just to highlight, strangely enough, the spike in cases is primarily located in the central New York area, particularly Tompkins County and Onondaga County, where we are. There has been a 179% and 117% respectively increase in those two counties. The State Department of Health issued a statement yesterday saying that they are monitoring the situation and that they are trying to figure out why this might have happened. There have been theories passed around that maybe this new variant entered New York State through Onondaga County. Who knows? But in any event, we're seeing the spike there in central New York first. Hopefully that is not a sign of things to come for the rest of the state. I point out this increase to, not warn everybody, but keep it on the front of your minds that policies might be changing. If they do, we will certainly let you know. You look at the HERO Act designation, will that come back? We haven't heard anything about that yet, but that's certainly a possibility. And then changes to the isolation and quarantine guidance that the state has been putting out rather frequently over the past couple of months. Remember that isolation and quarantine guidance most recently issued on March 1st is still in effect. So if you have employees who are testing positive or who have close contact with those who've tested positive, make sure you're following that guidance. Okay, so that's it for my brief update on COVID. We have a great program for you of substantive topics. First up is Krista Cook. Krista is a partner in our Syracuse office in the Labor Department. Krista's been on before, and what she's going to talk to us about today is very relevant and timely. It is affirmative action programs and OFCCP's federal contractor portal. So Krista, please, the floor is yours.
Thank you, Adam, and good afternoon, everyone. Thank you for joining us again on this Tuesday. Unfortunate news that, but good to know with regard to Adam's sort of update on COVID. Obviously, COVID's not going away as quickly as we'd all like it, much like our winter, which seems to be lingering here in Syracuse, New York. As Adam mentioned, looks like January out here in Syracuse, as opposed to the end of March. So I want to spend just a few minutes highlighting a few issues that won't be applicable to the entire audience that's listening, but I know there are a fair amount of folks that are listening. There are federal contractors. So for you federal contractors out there, there have been a few important legal developments in this area that we wanted to update you on. So Kathy, if you could next slide. The United States Department of Labor's Office of Federal Contract Compliance Programs, OFCCP, is the agency responsible for ensuring that federal contractors comply with the applicable laws and regulations covering their them as federal contractors. Certain federal contractors, not all federal contractors, but certain federal contractors that meet certain criteria must develop and maintain affirmative action programs or plans. And those are supply and service contractors with at least 50 employees that have a federal contract of $50,000 or more. And this could be a federal contract directly with the federal agency or government, or it could be a subcontract. And we're not talking about grants here. We've had several calls from clients about, am I covered under this as a result of grants that I might receive from the federal government? And the answer to that is a clear no. We're only talking about supply and service contractors here. Next slide. So the law itself has not changed in this area governing affirmative action plans and the obligations of when and how federal contractors are required to maintain those plans. What has changed is that the OFCCP has implemented a new platform. It's called the Federal Contractor Portal, and federal contractors and subcontractors must certify on an annual basis whether they are meeting their affirmative action plan obligations. So generally, this is a new reporting requirement. The OFCCP suspected that many federal contractors would create an affirmative action plan and not necessarily update it every year like they're required to do under the regulations. This is a way, this reporting requirement is a way that they can monitor that compliance. So this is a new website, run by the federal government or by the OFCCP. Federal contractors are have been able to register on this portal and for the past couple months. So they've had this window of registration. Hopefully, if you're a federal contractor, you've already done this, you've already registered. OFCCP has sent out emails, we know, to many federal contractors, sort of inviting them, encouraging them to do that. But if you know you're a federal contractor, you should go ahead and register for the portal. There are a lot of resources on the OFCCP website, and I've listed some of them here. There's a federal contractor user guide. There's a frequently asked questions, and there's some technical help desk information. A lot of that is mostly technical about how to register. There's some quirks that they've had to work through. For example, when registering, you're only entering the first 6 characters of your 2018 EO1 identifier for your company. So a lot of that is provided on the OFCCP website. And if you haven't done so already, you should register for that contractor portal. Next slide. So once they have everyone registered for the portal, the certification process begins. And that's sort of, we move away from the registration window to a certification window. That certification opens up on March 31st. So this week will be the first time that federal contractors will be able to certify that they are in compliance with their affirmative action plan obligations. You have until June 30th. So that is the certification window. By June 30th, all federal contractors should have registered and certified. So that is the deadline. and just a clarification, because we've had some clients ask, the OFCCP has clarified in some seminars that they've done that contractors will be required to certify whether at the time of certification they've developed and maintained an AAP. And I note that because of for federal contractors who have an affirmative action plan that might end during this period, right? Maybe it ends on April 1 or May 1. So contractors with an AAP that starts during the window in which they can certify, in other words, between March 31 and June 30th, they're going to have some latitude, right? As to whether you certify compliance for your 2021-2022 plan that you hopefully already have in place, or you wait and create your 2022-2023 plan. But if you're doing that, that has to be developed and ready to go so you can certify on June 30th. Next slide. So we've had some clients ask sort of what is the end goal here, and what is the implication of registering and certifying. This is a reporting requirement, and contractors who do not register and certify by the June 30th deadline, OFCCP has said that they will be much more likely to be selected for compliance evaluations. They're much more likely to be audited. But they want to make it clear that contractors who do certify are not exempt from it being audited. This is really just a mechanism for the for OFCCP to keep a better eye on compliance and sort of the pool of federal contractors out there. I wanted to mention that they are doing, OFCCP is hosting a webinar. Interestingly, it's on March 31st in the afternoon. That is been announced as something that they will be addressing a lot of certification process questions. So if you're a federal contractor, certainly go on the OFCCP website. You can sign up for that March 31st webinar. If you have any questions, certainly, or reach out to your bond attorney. But if you are, we do have clients that are hoping to certify on March 31st. So the sooner the better that you get all of this sort of in line. That's why we wanted to bring it to your attention today. One of the last points I wanted to make on this is that we've had some clients reach out to us and sort of trying to work through, are they a covered federal contractor? Right. And that's something you might need to work through with counsel. Others have informed us that, as an organization, they develop affirmative action plans sort of as a business recruitment tool or at the recommendation of their parent companies. We do not generally recommend that organizations who are not covered federal contractors and who simply voluntarily implement an affirmative action plan, we do not recommend that you register for this and certify on the portal, because of course you're signing yourself up for a potential audit, despite the fact that you're maybe not covered by the OFCCP rules. So that is sort of the federal contractor portal. Kathy, if you could go to the next slide. I want to just bring some attention to another development for federal contractors out there. The OFCCP has recently issued a new directive. So they issued a directive 2022-01. This was interesting because OFCCP has not issued any recent directives. This is the first one coming out of the Biden administration. And it's important because it signals that OFCCP, as we had anticipated, is going to be focusing more and more on pay equity and enforcing pay equity issues. This directive addresses federal contractors regulatory requirements, right? Requirement directly out of the regulations about the language quoted in this slide to perform in-depth analyses of its total employment processes to determine whether and where impediments to equal opportunity might exist. That is the language in the regulations. And these are regulations coming out of Executive Order 11246, as well as the disability and veterans statutes. So the OFCCP is sort of extended or interpreted that language and created this directive directing federal contractors that they should be conducting pay equity audits. I would note that the directive explicitly says that it is intended only for guidance purposes. It does not change the law. It doesn't change the regulations. The directive does not have the force of law. It's not binding in any way, which is interesting because, as you can see in this quoted regulation, it doesn't explicitly say that federal contractors have an obligation to create and conduct pay equity audits. But within that regulation, next slide, it does say that that they have to conduct an analysis of their compensation systems to determine whether there are any gender, race, or ethnicity-based disparities. So it's in that regulation that OFCCP is taking the position that that regulatory requirement requires you to conduct pay equity audits. In this directive, OFCCP is saying that they will be requesting and scrutinizing these pay equity audits in their compliance evaluations. And interestingly, a quote from the directive notes that the failure to provide the required pay equity audit will be considered as an admission of noncompliance with the regulatory requirements. One of the other sort of controversial aspects of the directive, and the pay equity audit is only one piece of information that the OFCCP has said that they will ask for if there is a disparity in your compensation system. One of the controversial aspects that sort of is yet to be determined about the directive is that the directive says that the pay equity audit documentation that they're going to request be provided is very broad. It says that contractors cannot withhold these documents by invoking an attorney-client privilege or the attorney work product doctrine, which is maybe concerning because many federal contractors conduct these audits with the assistance of legal counsel. But OFCCP is warning us that they're going to take a very aggressive approach and about any kind of claims of privilege. So there's extensive coverage in this directive about that subject. The directive even says that contractors who are in litigation with OFCCP may not withhold pay equity audits or any pay equity information by invoking the work product doctrine. It's very possible that this directive may be challenged at some point, particularly given its position on this privileged information. But federal contractors are going to want to work closely with their counsel to structure their audits in order to ensure that at least some portion of that audit remains protected from disclosure. The conservative approach recommended by the directive is to conduct 2 separate compensation pay equity audits. But we wanted to bring this to everyone's attention because what was, I think, known before as a best practice is now viewed by OFCCP as a requirement for federal contractors. So that's all I have on that, Adam.
Krista, thank you so much. That's a lot of very good information on recent changes in that arena. So thank you so much. All right, next up, is Lisa Feldman. Lisa's been on the webinar before. What Lisa's going to talk to us today about are some recent updates to EEOC guidance, in particular, new guidance relating to caregiver discrimination. So Lisa, go ahead.
Thank you, Adam. Good afternoon, everyone. So as Adam mentioned, the EEOC updated its guidance on March 14th. Next slide, please. It supplements earlier EEOC caregiver guidance, which is linked to within the new documents. And this update consisted of two different documents, which I've linked to here. So this way, when we post the webinar, people can click through. The first is a section I on the long technical assistance that the EEOC has updated periodically throughout the pandemic. And the second is a separate document about caregiver discrimination under federal employment laws. Next slide, please. And these guidance documents were crafted with the pandemic in mind. However, it's good for employers to be mindful of these issues on a more broad level. So the guidance makes clear that caregiver status as a standalone is not protected under the laws that the EEOC enforces. However, caregiver discrimination can violate EEOC laws if it's based on one of three circumstances. One, based on any protected characteristic under the laws that the EEOC enforces, such as sex, including pregnancy, sexual orientation, and gender identity, race, color, religion, national origin, age of 40 and above, disability, or genetic information. Two, if it's based on associational discrimination, and what that means is it's based on the protected characteristics of the person receiving care. For example, if the employee is giving care to someone with a disability or another protected characteristic. And the third segment is if it's based on intersectional discrimination, which is two or more EEOC protected characteristics coming together. For example, caregivers of a certain gender and of a certain sex and a certain race. Next slide, please. So it's a very lengthy guidance document. It was about 14 pages, but there were mostly illustrative examples. A few key takeaways, but I've highlighted some here. First, flexibility is generally not guaranteed for caregiving under EEOC laws, with one notable exception, that if an employee is unable to perform their job duties due to pregnancy, childbirth, or related medical conditions, they must be treated the same as other employees temporarily unable to perform their job duties. Next slide, please. Also, the EEOC stressed that even if an employer is acting benevolently, it could still be impermissible discrimination. The example they give is having a pregnant worker telecommute because you're concerned about the vaccination status of those in the company that are unknown. And for anyone who's been following along on our webinars, this should sound familiar because it's very much in line with what the EEOC promulgated earlier in the pandemic about age, that even if you're acting out of benevolence, you can't remove someone from the workforce because you're concerned that somebody older might have a higher risk of COVID-19. So the guidance also makes clear that an employer does not need to excuse poor performance due to caregiving. However, performance measures must be applied consistently and not based on any protected characteristic, and retaliation and harassment are prohibited. Next slide, please. And just on one closing note to quickly wrap up, I just want to stress that this presentation covered EEOC guidance only and the laws that fall under the EEOC's jurisdiction. But something to keep in mind for employers when approaching the caregiver discrimination issue is that there are maybe other federal laws where employees have protection, caregiving employees have protections, as well as state laws and local laws to keep in mind, especially here in New York State and New York City. So if anyone has questions about how to remain in compliance in totality, feel free to reach out to me or your favorite bond attorney. Thank you.
Lisa, thank you so much. I want to point out or highlight a couple of things. First of all, Lisa wrote a very good blog for our labor and employment blog, which is on the Schoeneck King website. So if you have any questions about this particular guidance, go on there and take a look. The other point I wanted to highlight is what Lisa just mentioned, which is the EEOC's scope is limited to federal equal employment opportunity laws. So, Title VII, the ADEA, the ADA, but there are many other concerns or other laws that you should be worried about. So in New York State, not only do we have our own human rights law, which sets out similar anti-discrimination protections for these caregivers, but also you have labor law sections relating to wage and hour laws and making sure that you're paying these caregivers appropriately. I know that that can become an issue, particularly in this context. So thank you, Lisa. That was great. Check out the blog if you have any questions. All right. Next up, a regular contributor to the webinar is John Godso. And John is a partner in our employee benefits group. John has all the answers for your employee benefit questions, and he's here today to talk to us about some upcoming reporting requirements under the Affordable Care Act.
Thanks so much, Adam. Good afternoon, everyone. Here to talk about, as Adam mentioned, the Affordable Care Act, everyone's favorite subject. I only say that with a little hint of sarcasm. I know many of you are probably going through or hopefully have completed the reporting cycle for 2021. Those reports, the 1094C, 1095C, were really due the first quarter of 2022 with a March 31st deadline for those reporting electronically. But I want to talk a little bit about some recent developments, some favorable, some maybe not so favorable, that maybe will give a window into what you might expect as a result of this year's filings. And I think the ACA is always a good topic. It's a topic that we get a lot of questions here at Bond on. And despite the fact that these reporting requirements have been in place since 2015, there often are a lot of issues associated with them. And it's not surprising. If you've gone through the 1094C or 1095C reporting process, you know that it's very complicated, very burdensome, very data intensive. And many of you are probably hiring third-party vendors. And even if you do that, we have seen mistakes occur. Obviously, the reports that get issued are only as good as the data that goes in. So your third-party vendors may be issuing reports that are not accurate. We certainly have seen that before. So it's something to really pay attention to, especially as we'll talk about some of the developments that have occurred over the last few months in this area. So if we can go to the next slide, please. So let's just reset ourselves with the general rules here. The reporting requirements apply to applicable large employers. Hopefully many of you who are large employers are aware of this general definition, which basically is 50 or more full-time employees or full-time equivalent employees from the prior year. And you're required to report whether you offer minimum essential coverage that was affordable and provided minimum value to your full-time employees. Self-funded plans have an additional reporting obligation about reporting with respect to enrolled individuals, and we use the reporting forms 1094C and 1095C to accomplish this. An issue to think about, and we've seen this with many clients, is that what you put on these reporting forms do trigger responses from the IRS, and many times we deal with clients who get a letter from the IRS, and if you're aware of the potential penalties for not offering enough full-time or permissible coverage to your full-time employees, you know they can be quite stiff. If you just have 100 full-time employees and you complete the forms wrong, you could be given an initial assessment of close to $200,000, for example. And even if the reporting, you can justify that reporting by a correction of the form, that takes time, effort, and money. So we want to make sure that we're completing these forms as accurately as possible, especially in light of some of the new developments here. So if we go to the next slide, please. So now, beginning in 2021, it's the expiration of the good faith transition relief period. So what does that mean? The IRS started these forms were first due back in 2015. The IRS at least understood at that point that they're very complicated, very data intensive, very easy to make a mistake on. So over the years, they've come out with this idea of good faith transition relief that's extended year over year, that, hey, if you're making good faith effort to complete the forms accurately, you're not going to get hit with extensive penalties for example, putting the wrong EIN number, or, for example, putting an incorrect notation on one of the forms for the type of coverage you're offering, because they understood it was a difficult form and it would be difficult, or there would be a high potential for errors. So that good faith transition relief period is over, starting with the filings for the 2021 year, which are being made now. And what we expect to see from that is likely higher scrutiny over the forms, and potentially a number of more letters that you might get from the IRS questioning the responses on your forms 1094C and 1095C. and a higher stake as far as what your burden will be to prove to the IRS that, hey, we completed these accurately, and it reflects the requirements of the regulation. So they are subject, or your returns or the penalties that may apply are under code section 6721 and 6722. If we go to the next slide, you can see that the penalties are pretty draconian. That's why we want to be careful in this area. For employers with 5 million in annual receipts, the late penalty for or incorrect filing or late filing is $280 per return. And that both applies with respect to the returns that you're sending to your employees as well as to the IRS. So you're really doubling that to $560, depending on, and then multiply that by your number of full-time employees. So it is a draconian penalty for sure. And as a result of the loss of this good faith transition relief, it's one that employers may have to be dealing with a little bit more, or more cognizant of when they're completing their 1094C and 1095C in the future. You can see there's also a maximum penalty amount. And if the penalty is due to intentional disregard, the IRS can increase the penalty as well. But regardless, even at the lower level, you're talking about a pretty extensive penalty that you want to avoid if possible. If we go to the next slide, please. So there is some relief already in the regulatory scheme that if you file a corrected form, you can have a reduced penalty. So if you're corrected within 30 days, the per return penalty is $50 with a cap. And if you correct by August 1st, there is a per return penalty of $110. So a significant reduction in the penalties. And another reason to be careful when you're filling out these forms and really mindful of what you're doing here. If you identify a mistake but have to submit the forms, you do have an opportunity to make a correction. And certainly if you make it within the first 30 days, you're talking about significantly reduced penalties. There's always a component of the law, has been throughout, that the penalties may be reduced or eliminated if they can show a reasonable cause. That's a fairly high barrier. It's not just a mistake, or you didn't have someone, you hired a new HR director who maybe didn't know exactly what they were doing. But to the extent that you do get a penalty letter, that would be what we would try to argue for you, that there was reasonable cause for making the mistakes on the 1094C or 1095C, but that is a fairly high bar. So we want to try to make sure that we're doing the forms correctly at the front side in order to avoid having to make arguments on the back side about how we did this properly. So we can go to the next slide, please. So that's the changes with respect to some of the more, I guess, changes that affect employers negatively with the loss of the transition relief. One other recent development is a little bit more of a positive, although this is something that this relief has been given every year based on guidance, but now it's becoming more formalized in regulations. The recent proposed regulations provide for a new due date for furnishing the Form 1095C to employees. The date that had always been ingrained was January 31st, but each year we got an extension until March 2nd. But that was a yearly extension that was provided by the IRS by notice. Now it's going to be baked into the regulations as far as extending that to March 2nd, March 3rd, if it's a leap year. So that is some relief for us as employers. We certainly expect these to be finalized. The IRS has said we can rely on the proposed regulations. So this will give us this additional time period, because January 31st is usually a difficult time frame to satisfy all these requirements, especially when you're just getting in data by the end of the prior year, typically December 31st. So that is a helpful extension for employers that will be continued in the future with respect to future filings. We can go to the next slide, please. So what are the takeaways? We started with the general rules. Hopefully by now employers have a good sense of whether they're an applicable large employer or not. Again, that applies to what's considered a large employer under the statute of 50 or more full-time employees. One trap for the unwary that we see in this area is this determination is made on something called a controlled group. So if you have related entities that have employees, those employees are going to get aggregated to determine whether you're at that 50 or full-time employee threshold. So that's something to consider, even if your organization may have less than 50. If you have a related organization and combining the two, you're over 50, you're going to be subject to these reporting requirements. We see that from time to time, that employers aren't necessarily aware of that rule because they're only looking at their own employees. The next takeaway is just basically, as a result of this loss of the good faith transition relief beginning this year with the 2021 forms, and in the future, they're really going to get inspected more closely by the IRS, we see, and it's going to be more difficult to make arguments that the mistakes that may have occurred in filling out those forms are not going to be subject to penalties. So we really want to make sure that we're reviewing them for completeness and accuracy. It's helpful in my experience when I work with clients to review a sample set of forms. If you have a lot of employees, it's sometimes impossible to review every single form. But if you review a sample set, you might get a good idea of where you are as far as if there's any mistakes and whether those are systematic or one-offs, and have a good idea of where you are as far as the accuracy of your forms going forward. If you're unsure how to complete the forms, again, they're complicated. If you look at them, lots of different codes to complete based on different fact circumstances. Consult with an advisor. Again, I know many of you consult or hire third-party vendors. They are helpful, but they're not always the answer. If you have a question, ask about it, because again, there are stiff penalties for mistakes. In the future, we're going to see probably a higher level of scrutiny by the IRS with respect to these forms. And finally, for those who do have a vendor, you might want to review your contracts to determine the party responsible for mistakes. Of course, if there is a large penalty being assessed against the employer, it's the employer's responsibility for the forms. However, if the mistake was made by the vendor, if we're looking at those contracts, there might be a shift of responsibility to the extent that they were negligent in completing the form. So that's something to look at just to understand where your risks are going forward. So I think big picture takeaways, the ACA is changing a little bit as far as how the IRS is going to look at these forms. The good faith transition relief is over with. These are complicated forms. Don't feel free to reach out to us if you have any questions, because we want to make sure you're in a position where you might not get hit with one of these outsized penalties in the future. Thanks, Adam. I'll pass it back to you.
John, thank you. Those are very significant penalties. So if you have any questions, call John or anyone in his group and they'd be happy to help you. All right, last but not least is Sarah Luke to give us an update on some recent developments with respect to the New York City Pay Transparency Law. Before those of you who are not in New York City shut down or log off, I want to let everyone know that there has been a bill already submitted in the New York State Senate that mirrors the New York City Pay Transparency Law and its requirements. So for those of you who think I'm not in New York City, this doesn't have anything to do with me, that may only be temporary. So Sarah, with that introduction, please go ahead.
Thanks very much, Adam. And yes, I agree that although we're going to be talking about New York City, this is really relevant to all employers. I think in light of what Adam's pointed out, and also Krista Cook's presentation that shows that the OFCCP is honing in on pay equity issues, this is just a hot topic, and plaintiffs' attorneys are going to be paying attention to it, and so we should pay attention to it as well. As you may recall, a couple of weeks ago, we talked about the recent amendment to the New York City human rights law that's meant to encourage pay equity and, more importantly, pay transparency. And we said, the law has been introduced, it's been enacted, it's effective in May of 2022. But in the meantime, we were waiting for guidance from the city. Well, that guidance was issued on the 22nd of March. And so here's what we know from that guidance. As you may recall, the New York City law requires covered employers to include a minimum and maximum salary for a position in any advertisement for a job, a promotion, or a transfer opportunity where the work can and will be performed in New York City. So one of our questions was, well, what is an advertisement? What's covered? And what kinds of publications would need to have this minimum and maximum salary? Well, we have some guidance on that issue now. An advertisement is considered a written description of a job, promotion, or a transfer that's publicized to a potential pool of applicants. So this applies to both internal and external postings. And the requirement applies regardless of the medium in which they're distributed. So it could be a posting online, it could be in a physical publication, all of that would fall under this requirement. The requirement applies to all postings where the work can or will be performed in New York City, regardless of whether that work is performed in an office, if it's performed on the field, or if it's performed remotely. So if you have an employee that lives in New York City and works from home, this could apply if the position is a remote position and the person is working from New York City. This could apply to that. The requirement applies to all categories of workers. Now, this is kind of a unique and counterintuitive thing. In a lot of other areas of employment law, we think in a wage and hour context of whether someone's really an employee, are they an independent contractor, interns are something different. But the New York City human rights law just looks at workers in general. So if you have a posting for an internship, if you have a professional services posting that could technically be considered an independent contractor, the human rights law considers all of those postings as covered under this requirement for the salaried minimum and maximum. You might wonder, well, what if we aren't used to having salary minimums and maximums in our postings? How do we figure out what they should be for the purpose of compliance? Well, the law requires that an employer make a good faith determination at the time of the posting of the lowest and highest salary that it would pay for the position. And by good faith, it's the employer's honest belief. Another area where this can be a little bit confusing, in the wage and hour context, we distinguish between salaried employees and hourly employees, or employees that are entitled to overtime, employees that are not entitled to overtime. There's no such distinction under the New York City human rights law. So the required disclosure has to be the base wage or rate of pay. And this is regardless of whether it's an hourly employee, someone that is paid on a flat fee basis, or on a salary basis. And the salary range is based on whatever that base wage or base rate of pay would be. An employer can't just say the minimum salary, and you can't say that the range is open. You have to actually have a minimum and a maximum, with one exception. If there is no range, if you know the position is $20 an hour and it's $20 an hour and you can't negotiate anything different, then you can just say that. But other than that, the commission's going to look for a minimum and a maximum. And this is without regard to how the employee or worker is paid. And now, many of you might be thinking, well, salary is just one part of the information that we would put in a posting, right? Often you can also put other kinds of benefits because you want people to apply, and maybe you have great benefits. Maybe the position is overtime eligible. Maybe you could get bonuses, health insurance, retirement benefits. Well, you can list those in the posting, but they have to be separate from this salary range because, again, it's just based on the base wage or rate of pay. Now, this law applies to all employers that are currently covered by the city's human rights laws, and it's enforced by the City Commission on Human Rights. Those of you who have any experience with the City Commission on Human Rights, you know that they are a zealous agency that takes their enforcement responsibility very seriously. In this case, failure to comply constitutes an unlawful discriminatory practice and could result in an award of monetary damages to affected employees and civil penalties of up to $250,000. So it's pretty significant, and it's important to take seriously. Now, with those additional helpful points of guidance from the City Commission, we have some recommendations. As I mentioned, the law goes into effect on May 15, so you still have a little bit of time. If you haven't thought about this much, and you want to make sure that you're in compliance and in good shape for when this goes into effect. First, we recommend that if you haven't taken a look at your current pay practices, if you're not sure how salary ranges are currently determined when you do a posting, or if you're not sure how the people of similar job titles are being paid now, like if you look at the organization wide, are there big disparities? We suggest that you take a look. And the best way probably to do that is through a pay equity audit. As Krista Cook mentioned in her OFCCP compliance segment, it's the same kind of principle here. And again, we do recommend that those audits are conducted at the direction of counsel. First of all, because that way you can make sure that the analysis addresses areas of potential legal risk, so you can get the most out of your audit. And secondly, to the extent that it's possible, we want to preserve the attorney-client privilege so that you're able to make corrections if you need to, and get legal advice, confidential legal advice in connection with that audit. And finally, as you're thinking about compliance moving forward, you're also going to want to think about the nuts and bolts of implementation. So how do you do postings right now? Where are opportunities posted? And are there separate procedures that apply for interns, contractor positions versus employees? Who are the current employees who are in charge of setting salaries? And are they aware of these new requirements? And if not, what can you do between now and May 15 to make sure everyone is aware of the procedures that you want them to follow and of these requirements? So I think with that, that's kind of our latest update on these issues, and I'll turn it back to Adam.
Sarah, thank you so much. We really appreciate the updated guidance. And just for everyone's edification, I put the New York City Commission on Human Rights document, the link to it in the chat. Okay, well, thank you everyone for attending another great Tuesday. We will see you again next Tuesday. And remember that if anyone wants to rewatch this presentation or look at the slides, they will be available on our website tomorrow. Thank you so much and take care.